Good morning, and thank you all for coming. My name is Robert McNamara. I'm a senior attorney at the Institute for Justice, and the Institute for Justice is the national law firm for liberty. For over 25 years, we have litigated in state and federal courts across the country, defending economic liberty, educational choice, private property rights, and the topic that brings us here today, free speech. IJ's free speech work has spanned protecting the rights of ordinary citizens to engage in political speech, to the rights of people to speak for a living on the internet or as tour guides. And today we're here to announce our latest free speech lawsuit, which we filed this morning against the SEC on behalf of the Cato Institute. You're going to hear from my colleague Jamie Kavanaugh, also of the Institute, who will bring you up to speed on today's lawsuit, and then from Clark Neely of the Cato Institute, who will explain Cato's role in this important First Amendment challenge. Jamie?
Thanks, Bob. My name is Jamie Kavanaugh, and I'm an attorney at the Institute for Justice. As Bob mentioned, we're here today to announce the filing of an important First Amendment lawsuit against the Securities and Exchange Commission. This lawsuit seeks to end the SEC's practice of silencing anyone who settles an enforcement action with the agency. In fact, since 1972, anyone who has settled an enforcement action with the agency has been forced to agree never to publicly deny or even question the SEC's allegations against them, regardless of their truth. But this is contrary to the First Amendment. The First Amendment protects the right to speak freely, the right of a free press, and even the right to receive information. But instead of respecting the First Amendment, the SEC is using the overwhelming force of the federal government to coerce individuals into waiving their First Amendment rights. But First Amendment rights cannot be bargained away during settlement negotiations. Put another way, the SEC cannot be in charge of who can criticize the SEC. And in fact, the SEC's policy has ensured that the public only ever hears one side of the story. But the best way to know if the government is overstepping its bounds is by having a public debate on the topic. And that's exactly what the plaintiff in this lawsuit would like to do. The Cato Institute would like to publish a book detailing one man's story of interactions with the SEC. However, the author of that book is subject to an SEC gag order, and therefore publishing the book is illegal. But this is government censorship of speech, plain and simple. And that's why the Institute for Justice and the Cato Institute are here today announcing the filing of this lawsuit. Now you'll hear from Clark Neely, Vice President for Criminal Justice at the Cato Institute.
Thank you. You know, when the government accuses somebody of misconduct, the Constitution presumes that that accusation will be adjudicated and determined in an open forum. That's why the Sixth Amendment to the Constitution provides that that everyone is entitled to a speedy and public trial when accused of a crime. That is how allegations of wrongdoing by the government are meant to be determined in this country. But we've completely changed that constitutionally prescribed approach. In fact, today 97% of all federal criminal convictions are obtained through plea bargain. And 98% of all SEC civil enforcement actions are settled rather than adjudicated. And what that means is that when the government accuses somebody of wrongdoing, the public doesn't get to see an open and honest airing of the government's case. They don't get to see the evidence, if any, that the government has to support those allegations. Instead, the case is decided through a backdoor, under-the-radar process that deprives the public of information about what the government does in our names. And increasingly what the government does is use an extraordinarily coercive set of tools that are used to extract confessions and plea bargains and settlement agreements, as in this case. The anonymous author in this case has written a truly compelling memoir of his experience being the subject of both an SEC enforcement action and a DOJ criminal prosecution. It is a story that people should hear. It's a story that the author wants to tell, and it's a story that the Cato Institute very much wants to publish in the form of a book. But none of that can happen for the simple reason that the SEC, like a number of other federal financial agencies, only wants its side of the story to be told and insists, when it brings the full might of the federal government to bear on people like the author in this case, it insists that as a condition of settlement that the defendant agree to a lifetime gag order. That flouts the very purposes of the First Amendment and the premise of open and honest government. We are going to challenge this perpetual gag order. We are going to win, and we are going to eliminate all such perpetual gag orders in all federal civil settlements. Thank you very much.
Thank you all for coming. We're happy to answer individual questions one-on-one. The lawsuit is Cato Institute v. SEC, filed in federal court here in Washington, D.C. this morning. Thank you.